Good morning, everyone. Good afternoon to the people in Florida, which includes our guest today. Thanks for attending the live cast. We do have a special guest today that I'll introduce in just a second. But first, I wanted to just tell you about the boot camp that we'll be having in Boston, October 2nd through 4th. If you have not been to Boston, if you have not been to New England in the fall, this is your opportunity to see beauty from nature. I used to live out there 40 years ago. Last time my wife and I were in Boston, we went up into Vermont and we hit the absolute peak week of color. And if you haven't been there, it's something that you really should see. That's why we scheduled it around this time. So October 2nd through 4th, we're having our seminar, our 3-day intensive boot camp in Boston. We are scheduled to have a boot camp this week in San Francisco beginning on Friday. If there's anybody that's close that would like to attend, we still, you could certainly sign up for that. I know that the time is short for any of you that need to travel to get there, but if you're close by, please feel free to come and see us. But by all means, if you aren't there, come to Boston. All right, and then shortly after the first of the year, we will be in Florida. We are scheduled to be in Orlando in January. And when we are, you'll get to meet this guy in person. So our special guest today, and we're excited to have him, is Damian Waldman. We have the law offices of Damian Waldman in Clearwater, Florida, and Damian does our foreclosures for us. He's done an outstanding job. We are really happy to have him on the line today. We get a lot of questions about foreclosure, and we thought, well, it's probably best if we get it right from the horse's mouth. So here we are. Damian, welcome to the live cast today. Really appreciate you making the time to see us. And how about if you just kind of give us a little introduction to you and your law firm and tell us what you do.
All right, sounds good, Ron. I appreciate you guys inviting me to join the livecast. I started my law firm in Florida. Florida is a judicial foreclosure state. I have 4 locations now in Florida, I'm happy to say. We moved very fast. We're probably the fastest and most accurate law firm in this state, and many others actually. But I expanded out to New Jersey. With the second state, I kind of expanded my practice out to. It's actually Waldman and Kaplan, PA, in Jersey. It's not the same name, but it's I partnered with one of my best friends, and that's also a judicial foreclosure state. It's actually the laws in New Jersey foreclosure as well as Florida are almost identical. Okay. I mean, they're so similar. There's differences, but they're very identical. The costs are a little different, but not that much. And we also, then I moved out to New York. It's a logical transition, I guess. We do New York. New York's a very nuanced state. It's also a judicial foreclosure state. I'm going to get in more depth with that. That name is actually Waldman, Daniel and Associates. And then I have a Pennsylvania law firm, which is also a judicial foreclosure state, which is D. Waldman Law, PC. And I have a Texas foreclosure law firm, which, well, it's not really foreclosure. We do all real estate related matters, but mostly foreclosures and collection matters. And that's D. Waldman Law, PA. And for mostly the entity differences they're all affiliated offices, all related to my law firm. My main law firm in Florida. It's just it was easier to make them different entities for purposes of accounting and everything else. And then I have a office in Wisconsin. I do practice in Nebraska. We don't actually have a physical office in Nebraska, but we do things in Nebraska, mostly in federal court. I'm admitted to about 12 different federal jurisdictions, 12 different states, and they also admitted to the U.S. Supreme Court. And we have Tennessee, which is also a non-judicial foreclosure state as well, and that's Waldman and Miller, PA. My partner and I are both admitted in Tennessee. And then I have Nevada, which is also a non-judicial foreclosure state as well as Texas and Tennessee, and that's Waldman and Porras, PA. And so we handle about, between me and all the attorneys and all the paralegals that we have, we handle about 9 different states, 3 of which are non-judicial and the rest are judicial. Take in mind that a non-judicial state can actually become judicial at any time. It all depends on the wording of the mortgage. If the mortgage has a power of sale provision in the mortgage, then it's non-judicial. If it doesn't have a power of sale provision, then it's judicial. The majority of them have power of sale provisions in the mortgage, so I would say 99% of a non-judicial state would be non-judicial. But you do have cases here and there that turn out to be judicial.
I had a question. It probably, why would you pick Nebraska? But that's all right. You don't need to. You don't need to go there. But so 9 states is where you're basically practicing. About maybe half of them or a little more are judicial states, and the rest are non-judicial states. Can you expand a little if there's any differences that, let's say, New York has versus Florida or whatever, and then you can get into maybe some timing and so on. And by the way, Damien is audio only because he didn't want to show me up with his appearance. So I appreciate that. But the next time he will do a PowerPoint presentation, and probably you'll be able to see his good looking face. But today it is just audio. So if you're concerned, he is not on the screen. So, okay, Damien, go ahead.
No problem, Ron. Okay, so some of the big differences really are with, for instance, with Florida, it's a judicial foreclosure state. We have to file a complaint with the court. The difference between non-judicial and judicial, obviously, you have to do court intervention. So you have to file a complaint, give the borrower or the defendant and all defendants a reasonable time to answer the complaint, which is by statute. In Florida, they have 20 days to answer the complaint. In New Jersey, for instance, they have 35 days to answer the complaint. In New York, they also have 20 days to answer the complaint. However, if they're a corporation, they have 30 days to answer the complaint. And so it's usually between the 20 and 35 day range. In Pennsylvania, they also have 20 days to answer the complaint. We have to file a complaint with the court. There are filing fees and various other things. And then if they don't answer the complaint, we move to default then, and we move for final judgment. We have to send them for hearing. And you have to go through the court system. Those processes can be long. My law firm, we do the best we can to make it the shortest time possible. We've been very successful at doing it faster than any other firm. And I say that with confidence. For instance, in Florida, at one point I was averaging between 3 to 5 months from complaint to judgment, and then sale is usually about 30 to 45 days out, depending on the county, and it could be 60 days out depending on the county and how backlogged they are, depending on what time it is. Like if we get a judgment in December or November, usually they won't set a sale in December for public purposes. Don't want to kick people out of their house during Christmas time. So then the sale might be in January, which would be a 60-day sale, for instance. And the difference between the judicial states is the most peripheral difference is they all have little nuances. Like, for instance, New York. New York is basically a 2-stage process. There is a judicial part of it where you have the court enter all the way up to the judgment. After the judgment's entered, the judge basically gets out of it, and it goes to the referee. There's a signed referee. Now, you can motion the court for court court intervention if the referee is not moving the case or not setting the sale. Now, we've been successful in New York where most law firms take like 3 to 5 years to foreclose, sometimes 6 or 7 years I've seen. We usually foreclose within a year or less. Usually it's within the 9 to 10 months range, depending on the referee. We usually get a judgment within 3 months, 3 to 4 months on average, depending on if it's highly contested or not. However, the referee process is usually about 3 to 6 months long, and it could be up to 10 to 12 months long, depending on the referee that's assigned to the case. And it gets kind of frustrating. And if it's an owner-occupied property, that also is could be a huge delay there as well. New York, like many other states, have mandatory mediation for homestead or owner-occupied properties. So, and mediators in New York, for instance, they have unfettered discretion to basically continue that mediation for as many times as they want to continue it, regardless whether you object to it or not. New York is a very consumer-friendly state, and everybody needs to be aware of what they're investing into. Your assignment of mortgage has to be recorded. If it's not recorded, they could dismiss the foreclosure. That's only if there wasn't already one filed. You know, if there's one already filed that their assignment of mortgage was recorded, then you take standing from them. But you know, that's not a requirement. For instance, in Florida, you don't have to record the assignment of mortgage. We just attach an unrecorded copy to the complaint package. But and the referee acts like a judge. The referee is either an attorney or a quasi-attorney, if you will, and they basically go through all the paperwork, go through all the affidavits, go through everything, and make sure that you have standing to sue, that you're actually the owner and holder of the note and mortgage, that you have that the amount that's owed to you is the amount that's owed to you, and that all the numbers match up, and they make sure that everything was properly followed. Like, for instance, the pre-foreclosure 90-day notice letter was sent out and filed with the Department of Financial Services. The 30-day demand letter was sent out. So it's a completely different process. Just like New Jersey differs from Florida and some of the other judicial states, as they have a sheriff's sale, whereas Florida has a clerk's sale. And in Florida, the judge enters the judgment the same day or within a couple weeks. In some counties, they set the sale. You have a sale date, and the clerk conducts the sale, and most of the time it's online, and that's it. In New Jersey, the judge enters the judgment in what they call a writ of execution, and you submit the writ of execution to the sheriff with usually between a $2,000 to $2,500 check to the sheriff. That's about the average cost of the sale, and with the package of the legal description and various other documents that you have to include, an affidavit of consideration and stuff like that, and they set the sale date. And sometimes, depending on the county, they'll set a sale date rather fast. Sometimes we have some cases in, say, Ocean County, for instance, that we've been waiting on a sale date for 3 months, and the sheriff told us they're 8 weeks behind from even setting the sale in our case. So we're going into 4.5 months by the time we're going to have a sale date set. And that's a case that we got a judgment in less than 6 months. But here we go, we'll be in the 10.5 month frame by the time we have a sale date because of that particular county and that sheriff. So there are some delays in foreclosure that are kind of unavoidable, if you will.
So I guess a question that pops up in my mind is what should the investor, the note owner, do? The people that are listening here that own a note that need to foreclose, what should they do prior to contacting you to initiate a foreclosure? Is there anything that would speed up the process if they would do before they send it to you? And just what kind of rules do they need to follow?
Well, there are definitely a lot of things that they could do to speed up the process. We don't have to send out the demand letter, even though I would prefer that we send them out. I can tell you a similarity in every foreclosure state, or every state to do a foreclosure, you have to send out basically a 30-day demand letter. Now, some mortgages will allow you 10 or 14 days, but keep in mind that the Fair Debt Collection Practices Act requires 30 days to dispute a debt. we always do rule from 30 days straight out. We usually give them about 35 days because of mailing, with another 5 days if they can reinstate. One thing I would tell you is that if you want to try to avoid foreclosure and avoid the cost and avoid the time, because no matter what you look at, no matter how fast we are, you're still looking at a year, you're still looking at 5, 6, 7, 8 months before you get certificate of title of that property. So, I mean, you're still looking at some time and money that you have to invest in it. And let's just say you got a loan you bought in default since 2006. Well, there's a couple issues there because you got to look at what state it's in. Has that loan been accelerated? Has the statute of limitations started running? Chances are it's probably not been accelerated because most states require pre-mortgages that we call installment contracts. So, and it makes sense. Every month they're supposed to make their monthly payment, so every month is considered a new breach of the mortgage. So you can make a new a default date basically by picking out a most recent default date. Like for instance, in Florida there's a 5-year statute of limitations, but when does that thing start running? That's actually a very long conversation, but because there's 3 schools of thought on it in Florida. But but you could basically, what I'm telling you is you could basically put your reinstatement out however you wanted to put it. There's nothing in law that says that you have to, they owe us $120,000. If you want that borrower to try to perform, I would suggest that you probably say, well, this is what you owe us. However, we'd be willing to work with you and accept $5,000 down payment and X amount of dollars every month, and we'll add your arrears to the end of the loan or something like that. You know, something more ascertainable for borrower to come up with. You can always send them letters like that. You can utilize a servicer to send out your default notices. Keep in mind the servicer is not an attorney, so they may not include all the appropriate things. They may not include an appropriate HUD counseling list. They may not include appropriate language and provisions from the mortgage in their demand letters. So just be very cautious about using servicers to send out your demand letters, but you can. And sometimes servicers do a good job, and they did all the research, and they just copied an attorney's demand letter or whatever they did. Anything to speed up the process. Because usually a demand letter and a notice of acceleration, most people call them breach letters, is a condition precedent to filing any foreclosure action, which is something that you have to do before you can file the action. And like I said, most states it's at least 30 days notice. And some states they require 60 days notice. And some of them also require they require an additional 90 days notice. Now, so most of them will run concurrent with each other, so you don't have to wait longer. But that's ways you can do it. Try to contact the borrower if you can work something out with them, as opposed to getting into foreclosure and collections and all the other stuff. If you send out that letter and that letter complies with the mortgage and by federal and state statutes, then that's one less thing that the law firm has to do, and we can move forward with foreclosure rather fast. Nothing else that you could really do. I mean, the only thing I would say is that make sure you have a full collateral package. You want to have a clear assignment in the lines chain. Now, keep in mind that if you try to buy notes with blank endorsements, you don't really need the allowance chain if you have a blank endorsement on the note, as long as it's the originator, or if you have an allowance to an X amount of person all the way down in the chain, and then there's an endorsement on it, that's fine too. You don't really need an allowance to somebody else if you have a blank endorsement, and that's pretty much standard in every state. I do want to let you know there is some recent case law in Texas about MERS. MERS very often assigns notes and mortgages on behalf of the original lender, its successor, and assigns. And because most of the time the original lender is way out of business, something like that, and and under the mortgage they have the authority to do it. Usually paragraph 2 of the mortgage, they have authority to assign the mortgage. It does not say they have the authority to assign the note, even though the note follows the mortgage, vice versa. In Texas, a recent judge ruled, and I think it's a poor ruling, but they ruled that basically they want to see an allowance from MERS on behalf of X, whoever it is, to the next assignee. or they're going to treat them as separate things. They're going to separate the note and mortgage out and declare that there's no standing in the case. Now, keep in mind, Texas is a non-judicial state, and not very many judges actually really deal with on a day-to-day basis with foreclosure cases. It's non-judicial, so I mean the process is rather fast. We can get a sale date. There's what we call Foreclosure Tuesday. First Tuesday of every month is the foreclosure sale date. We know what the sale date's going to be, and we just got to meet the time frame. Usually you have to wait about a 90-day. There's like a 90-day time frame. You have to wait 60 days before a sale can be set, and you have to send out a 30-day demand letter. But you can send out the notice of sale when you send out the 30-day demand letter. And usually we do that because it scares those borrowers. They're like, dang, I already got a sale set on my property, and I need to work something out with that lender. So they usually they're more willing to work with you in a non-judicial state because they don't think that there's normally in judicial states, because as fast we move, the borrowers think they have a lot of time just based on what they hear from other people and various other things like that. Now, when we foreclose fast, I'd be surprised how many borrowers come to the table right before the sale because they don't want to lose their house. But you want to have a clear assignment, a clear launch chain. If you can get a payment history, which is very hard to do with second mortgages, that would be wonderful as well. If the case gets contested, there's chances that we may need a payment history. Depending on what state it is, it doesn't matter. I mean, I'm talking about judicial foreclosures here. But in Florida, you would need a pay history. You could recreate your own. And you'd have to testify to that payment history. Now, in New Jersey, you don't have to have a payment history. You just testify to what's owed, and that's all that matters. Just sign an affidavit, and you're good to go. But it's different in Florida. You would actually need a payment history that you would have to either create or get, or we'd have to subpoena the previous lender for the payment history, and that causes delay in the foreclosure. So if you can get a payment history when you buy the loan, that's a good thing. You want to see if there's any other. This is something that nobody ever really gets. I've never seen anybody get it, but it's good to get the title policy and just in case there's any title defects, and usually that comes with the loan package. But you want to get a copy of the breach letter if it was already sent out. Maybe a breach letter was sent out already, and by a previous lender. Like, so let's say you bought a pool of loans from Citibank. Citibank sends out their own demand letters, and so they may already have a demand letter that's sent out. You want to send that to the lawyer that you're going to use and have that lawyer evaluate that demand letter, make sure it complies with both state and federal statute and the mortgage. Like I said, it's a condition precedent to filing any foreclosure action. So if it's not correct, your case can be dismissed. And if your case is dismissed, the other side has an attorney and the other side pled entitlement to fees, that would be ugly. I mean, they would be going after you for fees and get a fee judgment award. That doesn't really happen to us very often, but it does happen every now and then. And that's something that you should be considerate of. It's good to get as much as you can. If you can get the origination file, that's great. Usually when you buy first mortgages, you get most of that. Second mortgages, it's a lot harder to come by those things. I wouldn't discourage you from buying second mortgages just because you don't have those documents. I mean, there's a lot of times where those don't even become issues. Usually, if you're a smart attorney, you would move for summary judgment where you're not required to produce a lot of those documents. And if you get the judgment and summary judgment, there's no issues. And if you can't get a judgment, summary judgment, you just get the case ready for trial and you subpoena those documents. And you can most of the time get them from the lenders, or you can recreate the documents. So that's not something that you ultimately have to have, but it's something that you should probably have. I buy notes and mortgages myself, and usually when I buy a couple first, I just make sure I have a full pay history and I have the full launch and assignment change. And also I want to correct a misconception. An affidavit of loss to launch means absolutely nothing. It means absolutely it's a legal fiction. It means it has no legal effect whatsoever. Launches are supposed to be permanently fixed to a note. So they're supposed to be attached to the note, and they're actually supposed to physically attach them, like either by paperclip or by, kind of stupid, but it is what it is, or by like a staple. And if you lose no launch, then it really means you just have to get another launch. You can't get an affidavit of loss to launch. You'd have to get an affidavit of the lost note, and you'd have to basically lose the whole note to lose the launch. So you can't don't rely on the affidavit of loss to launch, but look at the assignments. You don't necessarily need the launch if the assignments are drafted correctly. When we draft assignments, they say you're assigning the mortgage and the note, so it's together with the note and the indebtedness and X amount of dollars. That does two things. It prevents a defense attorney from raising an issue, a defense. Well, we don't know when the note was assigned. How do we know that the note was assigned at the same time that the mortgage was assigned and that they actually have standing? And they make those arguments all the time. Well, if you have it on the assignment, even though most people know that you buy a note, then 2 years later you get your assignment. So it's kind of like, like a couple months later, 6 months later, or whatever else. You buy the note way before you get the assignment. But if you got an assignment that says that the note's assigned, then it's the same date as the mortgage, and it's a clear date. And if it's a good law firm filing a foreclosure, they're going to make sure they have that full chain before they file it, and they're going to have everything in place. We file everything. We actually file a copy of the breach letter with our foreclosure complaints, judicial-wise, and most law firms do not. It's a condition preceding to filing the suit, so it should be included. And we try to avoid contested issues. I'm more for moving cases as fast as we can move them. Like I said, I'm an investor myself, and the faster I can get a property and turn it, the faster I can buy another one. And I feel like that's the same way with my clients. And we move them very fast. I guess I can give you a timeline real quick if you want.
Yeah.
In Florida, like I said, we average usually about 3 to 5 months from complaint to judgment. The fastest foreclosure I ever did in Florida was 2 months and 2 weeks, and I got a 30-day sale date. So my client had certificate of title issued about 12 days later. So we're talking about less than 4 months, and the whole case was done. CT was issued. That's not bad. That's sometimes faster than the non-judicial states. Now, usually we're about the 5 to 7 month range now. Florida, I need to tell you that they just lost funding. At one point, what you call senior judges, retired judges that come back to the courtroom, and they basically are helping out with all the foreclosure backlog. And they were handling basically all the foreclosure cases, and we would have rarely weekly or daily or bi-weekly or dates for final foreclosure hearings. Well, the state lost its funding due to probably misappropriation in Florida, and so now they're back to the division judges, and that's every county. Well, some of the division judges' calendars are already packed out, and that is delaying foreclosures in Florida. I know that we have set some hearings in June for October. So we set a hearing in June, and the earliest hearing date we could get in that particular county was October. It's pretty horrible. However, we always try to see if we can push that date up anyway. I have a couple of staff, a couple paralegals that are designated to actually call the J's and see if there's any cancellations, see if they can move up hearings. Like I said, I'm all about moving cases and moving them fast. We always try to get the fastest date we can get, and not just fast, but correct as well. And in New York, we average usually about 7 to 9 month range, which is lightning fast in comparison to the other law firms. Well, Florida, most law firms take about 3 to 4 years in Florida, and in New York, like I said, about 5 to 7. In Jersey, we average about 9 months. That's including the sheriff's sale. We usually try to keep it within the year range or a little under in every state. Non-judicial foreclosure is a little different animal. There's not, you live in a non-judicial state, you ever had a non-judicial foreclosure, it's a little bit of a different animal. You don't have to deal with the courts. So usually we control our own sale, so it's good. Non-judicial states, we're the trustee. We're what you call a substitute trustee. We're not a trustee, we are the attorney, but we act as substitute trustee for the sale. and you know, you can get those done usually within 60 to 90 days, non-judicial foreclosures, depending on what it is. If it's an owner-occupied property and it's in Tennessee or Nevada, then there's mandatory mediation involved, which could delay a case by 60 days. Not normally longer than that, but usually about within 60 days. And most of the time, the borrowers file bankruptcies. There's advantages to using attorneys as opposed to using trustees to do non-judicial foreclosures for you, because that attorney can also immediately get you relief from staying in bankruptcy. Myself, I'm admitted in every bankruptcy court in every state that we have practicing, and I'm very good at getting out of bankruptcy court. Usually within 30 to 60 days, I'm in and out of bankruptcy court. A lot of lawyers can't say that. But the trustees that do the non-judicial foreclosures, and I have some friends that do non-judicial foreclosures and own a couple of non-judicial foreclosure trustee companies, and I don't want to steer business away from them. However, there's things that they are limited to because they're not an attorney, so they can't help assist you with an appeal. They can't assist you with a judicial if it turns judicial and they borrower sues you for a wrongful foreclosure, and they can't assist you for anything that would require judicial intervention. In Pennsylvania, our timeline is basically it could be really fast. It could be anywhere from about 6 to 7 to 8 months. With Pennsylvania, it's got an interesting process involved in it, whereas we only name the borrowers in our foreclosure. Like if there's just one borrower, then one borrower is the only one that's named in judicial foreclosure. Usually in every judicial foreclosure state, we run a title search, we title report, and we fully examine the title search to make sure we include all junior lien holders. Well, except with the exception of the IRS, we only include the borrower in Pennsylvania. And the reason why we do that is because we're foreclosing on the mortgage. And just an interesting fact about Pennsylvania is that you are not required to have the note. You're only required to have the mortgage. So if you have a clear assignment chain and you don't even know where your note is, then you're still good to go in Pennsylvania. That's not the case in Florida or New York or New Jersey, or any other state that I know of. But in Pennsylvania, it's and that's the way I think it should be. If you're foreclosing on a mortgage only, you should only be able to show. You only should have to show the mortgage. However, all the courts require us to also include the note. Pennsylvania is not the case. In Pennsylvania, is an interesting process. The sheriff also does the sale, just like New Jersey. However, after judgment's entered, what we do is we send a notice of sale out. We do a title report, the title search at that time. And then we send the notice of sale out to all the junior lien holders. So if you're the first mortgage, you'll send it out to the second and third mortgage and to any other liens that are on the property. You'll send them the notice of sale. You don't send them any notices during the foreclosure process, just during the sale process. And that's pretty much all the timelines, I guess. That would be all the.
Can you address one issue that pops up sometimes? People ask me, and that would be reinstatement, and then also kind of give an idea of, we've got a timeline, how much a foreclosure is going to cost in various places.
Oh, absolutely. I will give you all. Fannie Mae guidelines is everybody as a point of reference. Now, every state is different, but I can at least detail costs and also it's a new Fannie Mae guideline around 975 to 500, just attorney's fees and uncontested foreclosure. Now, if
can you repeat that? Can you repeat that, Damien? For some reason, it broke up on my audio. I don't know if it did for everybody else's, but can you repeat that, please?
Yes, sir. No problem at all. I'm actually I'm hearing it. If they could fix that. All right. So let me just. Florida Fannie Mae guidelines is $2,800 flat fee, uncontested. Those are attorney's fees. That doesn't include the cost of foreclosure. Now, the cost of foreclosure in Florida, and I'll get very, very specific, it depends on the cause of action amount. It's not based on the unpaid principal balance. It used to be based on the unpaid principal balance. Now it's based on the total cause of action amount, which is basically the principal and interest. And so principal and interest, if your cause of action is under $50,000, your principal interest is under $50,000 in Florida, your filing fee with the clerk is anywhere from $401 to $507, depending on the county. The clerk also charges a convenience fee of anywhere between $3 and $3.50 they're all like electronic filing in Florida. Plus $2.50 per defendant over 5. And so basically the filing fee covers 5 defendants. If there's more than 5 defendants, you got to pay an extra $2.50. It's just a huge ripoff with these clerks in Florida. The fact that this is the only state that does it by cause of action amount is also very frustrating, dealing with many other states. Their filing fees stay the same, regardless of whether you have a $250,000 mortgage you're foreclosing on or a $100,000 mortgage. It varies in Florida. In Florida, if the cause of action is over $50,000 but under $250,000, then you have anywhere from a $901 to $906 filing fee, depending on the county. Plus the first convenience fees, and plus it would be additional $2.50 per defendant. Now, if you're foreclosing on a property where your mortgage is over $250,000, then you're looking at a $1,906 filing fee to the clerk just to file that action, plus the convenience fee, plus the $2.50 per defendant. For every summons that's issued in pretty much every state, it's usually about $10 to $11 to $12. In Florida, it's $10. In Pennsylvania, it depends on the county. It could be anywhere from $10 to $13. Most states, it's $10 to issue the summons. Some states allow you to issue your own summons. And service of process, it does vary. In Florida, we shopped around many different times, paid a little bit less money, paid a little bit more money, and sometimes you have to pay a little bit more to get a little bit. You get a lot more. And I found very good process servers that are able to serve the defendants in a very fast manner. And in Florida, they charge $65 per defendant in state. If it's out of state, it's $125. Usually that's about average for most states. New York and New Jersey are the most expensive service process states. They're usually between 75 and between 95 and 115, depending on the process server, and that's in-state service. Out-of-state service, usually we try to get somebody that does the cheapest, so anywhere from $125 to $175 for out-of-state service. We also pick process servers that will not charge for multiple attempts. If there are multiple attempts at the same address, and I do that for my clients because you'd be surprised how many people are complaining they got a $5,000 or $1,500 service of process fee bill from their attorney, and they're like, this is outrageous, especially if their note was $10,000. And there's only 3 people to serve, but it does happen, and we try to avoid a lot of that by getting process servers that agree in writing that they will not charge for multiple attempts at the same address. They do charge for attempts at different addresses if they have to attempt at different addresses. However, I do have a system in place. I actually paid for AccuRink, which is a public search database, and we're able to ascertain and locate the borrower usually. Sometimes we can't, but usually we, because they either move and there's just no way to locate them, and we have to use a process server to do that extra step. But to locate the borrower, so we have the correct address for them, and it saves our client time and money. And but usually title searches are usually anywhere from $375 title search and examination to $450, depending on the state. And list pendants recording in Florida, for instance, is $4 for the first page, $5 for each additional page, which usually is no higher than two pages. Usually it's about $9. depending on the county, you might have to pay for proper names over 2. And it's all proper names, including plaintiff and defendant, $2.50 addition. Usually the cost in Florida average about $1,500 to $3,000, depending on the cause of action amount. That's just the cost. Then you add in the attorney's fees. I usually give small investors a deal. Usually I give them below Fannie Mae guidelines, which is $2,750 flat fee. That's it saves them a little bit, and we charge a reduced hourly rate for the foreclosure. But so, for instance, in Florida, so if you got a property that you're foreclosed on, and the value of it's over, the unpaid principal balance and the interest is over $250,000, and you're looking at probably close to a $3,000 cost, and then you're talking about another $2,750 in attorney's fees. So we're talking about $57,000 to $6,000 just for one foreclosure action. They do get expensive.
Okay.
And then in New Jersey, Fannie Mae guidelines is $2,975. Between that and $3,500. Usually we charge. Well, actually, never mind. That was the old guidelines. The new guidelines under Fannie Mae is $3,800, but we charge anywhere between $2,975 and $3,500. And we charge a reduced hourly rate. It's actually always lower than all the other firms. So we might charge a little higher of a flat fee, but our hourly rate, if it gets contested, is extremely lower in every state actually than it is in the other comparison law firms. They might charge a little bit cheaper flat fee, but their hourly rate's going to be higher, and we kind of make up for that because if the case gets contested, it can get expensive. We only charge for what we have to do to get the case to a judgment. We don't unnecessarily bill. I'm big about that because I'm all about my clients and making them money, and you're paying money in attorney's fees, a lot of money in attorney's fees. You're taking more money out of what you're going to make. And that's why I try to move the foreclosures as fast as I do. It's hard for them to get really contested, highly contested, when they're moved so fast. Usually we do things like we'll set the case for trial immediately if we know that the defense attorney's really pushing stuff and send us like 5 things of discovery and wants to do a deposition and stuff like that. We may still have to do those things, but we'll have a trial date set, and that will cut off their ability to do very little. It cuts off their ability to rack the bill up. In Texas, for instance, the Fannie Mae guidelines are. Well, the Fannie Mae guidelines in Texas, are $1,325, and that's usually what we charge because it's a system, the process involved in it. I don't know if I can get any cheaper than that now, but we do charge that. We usually charge a reduced hourly rate. Most law firms charge about $275 an hour, and we charge like $195. So it's a lot less. It's considerably less if it got contested. Usually they don't get contested; they're non-judicial. Non-judicial foreclosures per Fannie Mae guidelines in Nevada are $1,525 in attorney's fees. In New York's by far the most expensive foreclosure state, as you would imagine. New York is very expensive. Usually, the funny thing is, all law firms go from different rates. You can call somebody up and they might tell you $6,000 to do the referee process. We are not like that. We actually have a reduced flat fee for the whole foreclosure process, as long as it's uncontested, of course. And our hourly rate's a lot cheaper than the other law firms as well. They all usually average between $350 and $475 in New York, and we're extremely below that. Usually we're about $195 to $200 if it's very complicated. But we usually charge $4,975 for the total uncontested foreclosure. That includes the referee process, and the cost of the foreclosure in New York, the filing fee is the same regardless of the cost of action amount, $400, and services more expensive, like I'm saying. It could be anywhere from extra $1,200 in cost, usually on average. All foreclosures, because of what they are, like Pennsylvania, I think, is the judicial state where the costs are not as high because you don't have to, before the sale takes place, because you don't have to serve all the junior lien holders and any other lien that's on the property. You have to, you still do title search, but you're just serving the borrowers. You're just their filing fees are usually $190 and $250 at the max, depending on the county. I would actually say $230. And so a foreclosure in Pennsylvania, you might be paying, like $3,200 total for the foreclosure process, and that's a lot cheaper than. It's a lot cheaper in a lot of the other states. Now, keep in mind that sale in different states. In Florida, it's cost per state. Like if you're in South Florida, you're usually paying anywhere from, well, it used to be $195. Now they upped it between West Palm Beach is $210, Broward and Miami or $230. That's the newspaper that we use for publication. Most of the other ones are more expensive. That's actually a widely used one and very trustworthy one. And usually where I'm located, where this main office is located, we have it's usually like $165 is the publication cost of the sale. Usually the cost of the sale are about $300 to $400. That would be the additional cost. Now, we don't charge any attorney's fees, for instance, in Florida, unless we have to physically go to the sale. There are some counties where we have to physically go to the sale. So we usually charge either a reduced flat fee or an hourly rate, depending on where the sale is. But it's usually included in the flat fee if it's not a sale that we have to personally go to. For instance, like I was saying, in New Jersey, usually you have to pay the sheriff to do everything for the sale. And that's usually between $2,000 and $2,500 that they have to pay just for the sheriff to give you a sale date, publish the sale, and includes publication of the sale and everything else. In Pennsylvania, it actually gets a little even higher for the sheriff to publish the sale. It could be anywhere from $2,500 to $3,500 for them to publish the sale. So they charge. So foreclosures are expensive. There are a lot of costs involved in them. A lot of people have misconceptions about foreclosures and the costs involved. And I'll tell you, these are all estimates.
So
because
when we were talking before the presentation, Damien, you mentioned to me that there were some new regulations. Before we get off, can you alert the audience to what these new regulations might be, and then also be sure that you give them your contact information if they have a foreclosure that needs to be initiated in the states that you do business in?
Okay, absolutely. So we got case law that's actually good in Nevada. It's a brand new case that just came out. It allows you to basically, you can collect under the deficiency judgment where a certain non-judicial foreclosure state does not allow deficiency judgment collection. Like, for instance, let's just say that in Georgia, it doesn't allow you to do a deficiency judgment. It does, but if you have a borrower that has property in Nevada, then you can actually attach that judgment to that property, make it a lien, and you can foreclose on it or collect against it. That's brand new case law that just came out this year. It's Branch Banking and Trust Company versus Windhaven and Tollway. I think that's good case law. There are some case law that I want to mention that's relatively new. You probably already know about it, especially if you're in this field already. Keep in mind that in Nevada, HOA liens are super priority liens, and they can foreclose out a mortgage, or well, it's really a deed of trust. The difference between non-judicial and judicial foreclosure is also you're dealing with either a deed of trust and judicial foreclosure, you're dealing with a mortgage. And I have a lot of clients in California, they always send me the mortgage and call it a deed of trust. Well, I mean, it's a deed of trust, but really it's a mortgage, because there's judicial and non-judicial. But, I want you to be aware that HOA liens in last year, they ruled that it's a super priority lien and it can foreclose out a deed of trust. As well as in Florida, a second mortgage can be foreclosed out by a HOA lien. So you want to make sure that you know that there's HOA liens on the property or not when you buy a note and mortgage. If there are, how much are they? And you can probably negotiate them down and pay them. It wouldn't dissuade you from buying a note and mortgage because there's an HOA involved, especially with the second. But a lot of times with seconds too, we can foreclose on an HOA, and the HOA doesn't know any better, doesn't know you're the second, and sometimes you can get safe harbor, which is in Florida is 12 months of unpaid assessments or 1% of the original unpaid principal balance, whichever is less. There's a couple new case law. I mean, I'm sure you guys are aware of the case law that affects both judicial and non-judicial foreclosures. Is most recent case law from the United States Supreme Court regarding stripping of liens. I think I got an email on Ron when he was talking about that. You guys already, everybody heard about that case. But that's a good decision. The code did not allow for a Chapter 7 stripping. It allows for 13 stripping. Just to do some clarification on that, it does not affect the debtor's right to strip a unsecured lien in a 13. However, they have to complete the plan, as you know, to strip the lien. They cannot do it regardless of equity in a 7, and that is a proper ruling by the United States Supreme Court. I'd love to argue that one. But, there's a little bit, there's not like a whole lot of new case law that's come out recently. I mean, there is some case law in Florida that's worth mentioning. January of this year, there's this case called Pervase, and it's making it kind of difficult with statute of limitations issues. In Florida, up until this case was decided by the 3rd District Court of Appeal, basically there was two schools of thought on when the statute of limitations starts running on a mortgage foreclosure. And one of them is that it starts running when the cure date of the breach letter expires. So they send out that 30-day demand letter, and when that cure date expires, then the SLL time starts running. Well, and that was a predominant way of thinking in the majority of the Supreme Court has not ruled on it as of yet, and that was the Bartran case. And there's another case. Well, there's another school of thought, which is a lot of group of cases, that says that mortgages are treated as installment contracts. And this is the wide belief of most states, that they're installment contracts and every month is a new breach. Texas has the same rule of reviewing, and so does New Jersey, and so does New York. And they all have mortgages are treated as installment contracts. So if you have a 5-year, and a lot of times you buy notes and mortgages, and they stopped paying on their mortgage in 2006 or 2015. That was 9 years ago. So do you have an SLL issue? Well, it depends. You probably just need to increase that default date within the 5-year range. I wouldn't recommend increasing it so it's right in the 5-year range. I'd increase it within a couple years within the 5-year range so you could have some breathing room. You never know, borrower might reinstate. Now, if borrower reinstates the mortgage, then you start the SLL all over again anyway. But that new case in front of the 3rd District Court of Appeal, basically distinguished all the other cases that we had in Florida on statute of limitations issues. And it said that the statute of limitations starts running at acceleration, which is basically what every other state says as well. But when does a loan accelerate? We'd argue that it doesn't accelerate when we send out the demand letter, because the demand letter says, by virtue of the language of the mortgage, that your loan may be accelerated. It doesn't say shall, it says may. And under legal terms, there's a big difference between may and shall. And so they ruled that it accelerates, in which that part I think is proper, but I don't really agree with their ruling 100%. Is that it's definitely accelerated when you file an action. So when you file a foreclosure action, the SOL starts running. So if you dismiss that action, or that action gets dismissed, and 5 years have passed since you file a new action, then according to them, you are barred from filing a new action. Now, that's only if you didn't deaccelerate the loan. Now, what is deaccelerating the loan? Well, you send a notice of deacceleration to the borrower, basically by saying, hey, I'm hereby deaccelerating this loan. I'm making you now, giving you an opportunity to cure the default. Now, it doesn't really say you have to deaccelerate this loan and make this loan current minus escrow advances and basically give the borrower a chance to start paying on the mortgage again. It implies that, but it doesn't say that. And I think there's other ways of doing it as well, that where you can just pick a new default date, send out a notice of deacceleration, and move from there. The case that was decided in that most recent case, Berbace, is it's unique facts to that case, as all legal opinions, and it had no deacceleration. There was a previous foreclosure action that was dismissed. 5 years it ran. It filed a new foreclosure action, and the court said because the loan wasn't deaccelerated, that the case was barred. Now, they also said that the lien remained on the property. A lot of people would think, well, it's actually good for second mortgages, now the first can't foreclose. Well, it's true, they can't foreclose up to a certain point, unless they deaccelerate or send the borrower a mod or something like that, or give them an opportunity to cure, reinstate. Now the lien remains on the property. So the lien doesn't go away just because their ability to foreclose might be hindered, but it may or may not be hindered. In Florida, it's governed by of course, the Florida Supreme Court and the U.S. Supreme Court. So basically, that's not a binding opinion on the whole state of Florida. It's only binding in the 3rd District Court of Appeal, which happens to be Miami and Monroe. And if you buy a note in Florida, you probably bought a note in Miami, because everybody has notes in Miami. So, I mean, there's a whole lot of foreclosures in Miami. I started my practice, the majority of my foreclosures were in Miami, and the majority of my foreclosures now are still in Miami. So that case is very important to mention. It does have different interpretations of the case. We represent a lot of first lien holders, and what we do is we deaccelerate the loan. We try to make the loan close to being current. If you have a certain amount of loans, you don't fall under the small servicers exception. You have to wait 120 days before you can file a foreclosure act, CFPB. I like to have maybe a seminar on CFPB guidelines and the changes of that. It's pretty intensive. And also closings are going to be changing. We also do closings, just to let you know, too. We don't just foreclose on people. We do closing and
okay.
Happier faces. We do a closing as opposed to foreclosing on people. But the people that we foreclose on, they discovered it. They're not paying on their mortgage.
Great. All right. We're going to have to wrap it up here, Damien. Could you just be sure that people have your contact information? If they miss it, they can certainly contact us, and we will provide it for them. But would you give it to them? And then I thank you very, very much. Thank everybody else for attending, and very, very helpful information, a wealth of information. I know foreclosure is a concern from a lot of investors. It's really not that huge issue when you have somebody like Damien on your side. So, Damien, thank you very much. And can you give your contact information to the audience?
Absolutely. I'm sorry if I was long-winded too, by the way.
No. I know it's a very intricate and hard subject. So, I mean, we could spend another couple hours at least talking about it, but if you could give them your information, I'm sure there's a lot of people that need your assistance.
Oh, absolutely. Well, let me give you my phone number. My number is 844, so 1-800 number, might as well give you that number, and 899-4162. It's 844-899-4162. You can dial 0 and bypass all the crap, and talk to Michelle, who's a receptionist, and if you want to talk to me, tell her you need to talk to me, and she'll transfer it to me. Say I'm a note buyer, and I bought a note, and I need a foreclosure, and she'll transfer it on.
Great. All right, Damien.
My email is Damien.
Go ahead.
Yes.
I'm losing you there. Damien.
Can you hear me?
I can, yeah. We need your email.
Okay, did you get what I said a second ago?
Please say it again.
Okay, well, the phone number is, sorry, let me get to it normally. Phone number is 844-899-4162. And I would press 0 to bypass the huge message. We are a debt collector, and blah, 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 blah. And talk to Michelle or Stefan or Scarlett, whoever answers the phone. I have 3 receptionists, and they can direct you to me. I can give you my email. Email is always the best way to contact me. I check my emails constantly, probably all day and all night. I don't really stop working. And I always respond to an email immediately. I think that's a very important thing as an attorney, and it's probably the biggest complaint that people have with attorneys is that they don't respond timely. And I respond immediately. Usually within a couple minutes of the email it's sent to me. But my email is Damien, DAMIAN @dwaldmanlaw.com. It's DWALDMANLAW.com. And that's the best way to reach me. Actually, I don't mind giving my cell phone number. It doesn't really matter. My cell phone number is 404-547-8767. Be mindful of the time. Try not to call me at like 9 o'clock at night or 10 o'clock at night. My wife always gives me the evil eye. But I'm always available if you ever have a question or concern. We also help do due diligence for clients. A lot of times we don't charge for it. Well, if there's a huge amount of them, we got to charge for it. It's just a huge amount of time involved in it. But we help try to educate the note buyer before they buy the notes, so they know what they're getting into. For instance, I did a huge note evaluation involving actually there's 6 states that I cover, and that was the majority of the pool. And it was about 700 notes that one of my clients was buying. And so we did an evaluation of it, and it turns out that almost half of those notes were notes that I would not buy. Like they were missing things that you wouldn't be able to enforce the note on, or the case was dismissed with prejudice, which would not allow you to bring a new case. And there were some pretty bad things. So we had looked up the cases and found out what was going on, and the client really appreciated. Did not bid on the bad notes, bid on the good notes, and it was good to buy a good note. It's always there's a couple things I want to say real quick if I could. Ron, I don't want to take a lot of time, but there's some important things I want to mention. With tax deed sales, you need to be very careful to watch tax deed sales. And one thing to prevent that is that when you get an assignment of mortgage, make sure your assignment of mortgage has your address. and has the correct address on it. Because if it doesn't have your address, for instance, in Florida, you're basically SOL'd. If you lose that property tax deed sale, which it will foreclose out your mortgage, you're done. And if there's no address, the clerk has no obligation to notify you, just the previous person that sold you the note or the person before them. And they have no obligation, no legal obligation. They might have the moral obligation to notify you, but of a tax deed sale. So I would make sure every time you have an assignment, regardless of what state it is, that you include your full name and your address, including the deeds. Any deed that you have, it's the same thing. And the side note is in New Jersey, if they actually have to foreclose. They have to file a judicial foreclosure action to foreclose on a tax deed. So even if there's a tax deed on the property in New Jersey, you don't have to worry about it as much. Still got to worry about it. Still got to pay the taxes, but you don't have to worry about them just setting the sale date like they do in Florida. It's basically non-judicial in a way. It is non-judicial. The clerk sets the sale and that's it. But I wanted to make sure that everybody was aware of that. And I'm available anytime to speak to.
All right. Well, thank you very, very much, Damien. I know everybody appreciated this. It's great to get to know you. Look forward to you coming to California, and we'll see you in Orlando for sure in January. So thanks again, and thanks everybody for being on. If you have any questions, please get them in an email, and we'll get them on. Thanks a lot.